Hey out there, legal warriors. This is a very important video. There is a new law that went into effect July 1st, 2022 that can affect all of us. And if you're interested in what the new law is, it covers restraining orders. And what are some of the bad things? There's a lot of them. Stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. So if you find this video useful, please like and please subscribe. More people will get the education I'm trying to put out there for the good of all of us. And so, yes, my law firm defends people charged with crimes, but we've also helped people defend restraining orders and occasionally help someone get a restraining order. And, I have a lot of videos on the subject of restraining orders, but now some of the stuff has changed. And a big new law went into effect just a few days ago on July 1st, 2022. It may not be a few days ago now that you're watching this. And we're still trying to get on top of what it means. But I went ahead and printed out the law, and I put it in something I call my binder of tears, because as a person that looks out for people accused of things, a lot of the law changes here, and it's pretty thick here, a lot of the law changes really favor petitioners and provide a lot of possibility of abuse of the system to take advantage of people, right? And so in this video, I'm going to cover just a few of the things that have me worried. So I'm going to set down this binder and just jump right into it. So what are the changes? And I'm going to put out future videos about how it's working in real life, because there's only been one day, July 1st, I went to court on an order, and the court really wasn't doing any of this new stuff yet. But here's what some of the law says that worries me. The first thing that I see is, in a restraining order, what is the same as someone could go in, because that's how it works, and ex parte, which means one side only, claim that they need some help because whoever the respondent is has done something wrong, that they're harassing the petitioner, that they've committed domestic violence against the petitioner, that they've committed some type of other assault against the petitioner, stuff like that. And so the system is designed, and always has been, that the court could issue a 2-week temporary restriction on the respondent just on the one-sided say of the petitioner, and then they would set a hearing to determine whether or not it was really true. The respondent would get a chance to say their side. And so that part of the system is still the same. However, now this new law says that the court has all these broad powers to order whatever relief it sort of feels like by the one-sided story, right, against the respondent. So the court can say, oh, that's really terrible what you wrote, petitioner, true or not. They're just assuming it's true, and order that the respondent have a GPS monitor put on their leg at their expense, upon pain of contempt of court if they don't, right? And you can go to jail for contempt of court. So the court can also order someone to have to do expensive treatment, right? Hey, go do a year's worth of domestic violence treatment just because someone says that you did something, even though your side of the story hasn't even been told yet. I don't see how that's fair, right? I don't agree with that, and I'm hoping that the courts don't do that routinely. There's other things the courts can do too. They can order mental health treatment. I'm all for mental health treatment, but court-ordered with only one side heard doesn't seem right to me, okay? This is really scary from a personal rights point of view, and that's why the law right there in the binder, I may not call it binder of tears, and let's hope it works differently. So the court has been told by the legislature, we're going to give you all these powers to do all these stuff to people without any notice or due process, right? And I just don't think that's how it should work. So that's one thing that I see that's problematic. A second thing that I see as problematic is the service, right? This new law allows for service by publication very quickly in the process, okay? In a case where someone goes in and gets an ex parte order, one-sided order, well, there's a date that's set 2 weeks later for the respondent to appear and challenge what the petitioner is saying against them in this restraining order. And if the respondent never gets served, the police officer doesn't find them for whatever reason, then what has to happen is the court will give the petitioner another 2-week temporary order and give the petitioner more time to serve the respondent. And the law still says the respondent has to be served 5 court days prior to the hearing, but now the law says after just 2 attempts, or even shorter on good cause, notice even after 1 attempt even, the court can authorize service by publication. And no one ever sees anything by service by publication. So basically this law says, hey, if you can't serve them, we're going to let you publish it in some newspaper, publish it somewhere, and then the courts just can default order against somebody. So I can foresee situations from doing this type of work for a long time where someone doesn't even make a good faith effort to serve them, right? It doesn't always have to be law enforcement serving, right? They can try to do private service. Well, I tried to serve them. They might not even try. Well, let me do service by publication. They publish it. The respondent never sees it. Now they're have an order against them, right? They might have a permanent order that lasts forever against them and they never knew about it. And there is a way, although it's very vague in the law, to go in and challenge that later, right? Like a motion to reconsider and things like this. It's all set up in the petitioner's favor, where the legislature is presupposing that the actual people seeking help really need it. And I'm all for the people who need help getting help. I was a prosecutor for 7 years. We represent petitioners. We represent victims. But let me tell you, time and time again, we see petitioners saying one side of the story and literally making stuff up to try to use this law that's supposed to be a shield as a sword, to try to cause damage to people, to take kids from people, to get people thrown out of their home, things like that. And in no way should the legislature have set this law up like this, in my opinion. It's just, it makes my stomach turn. And I think the third thing I want people to know about is probably even more troubling than all the rest. The way I read the law right now, and I hope I'm reading it wrong, but it seems like it's in black and white, it says that if somebody files a petition for a restraining order and the court finds that they're not entitled to relief, that hey, they haven't stated a case and therefore they're not entitled to an order, it says the court shall set a hearing anyway in 2 weeks and command the respondent to show up, right, and explain things. And are you kidding me? That means a petitioner could write in the petition against anybody they want, blah, 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 the sky is blue, and I want a restraining order against Mr. Smith. And the court could look at it and say, well, you have no allegations against Mr. Smith here, but the law says I must set a hearing and command Mr. Smith to come in. Well, Mr. Smith's got to go get an attorney. Mr. Smith has to miss his work. Mr. Smith has to freak out, and the whole system is in some serious trouble, right? And so how I read what it requires is that even if the petitioner is wrong, even if the petitioner isn't stating a claim under the law, and plenty of cases are like that, that the court isn't free to just say, sorry, this law doesn't cover what you want, petitioner. No, the court has to say, sorry, this law doesn't cover what you want, but have a hearing in 2 weeks anyway where you can claim some more stuff, right? How it works before this law is the court could have discretion. It could look at the petition and say, this is totally bogus, goodbye, and the respondent is never bothered, because why should they? It was totally bogus, according to the court. It didn't even apply. Or the court in the past could say, well, it doesn't really state something, but there might be something here. I'm going to use my experience and discretion to go ahead and set a hearing. But no, this legislature has said, no matter what you file, that you get a hearing and the respondent has to come in and deal with it, even if the court believes it doesn't apply under the statute. And that just can't be right, right? That better not be how it ends up working. And if that is how it ends up working, there's going to be some very upset respondents, some very upset judges, because they deserve that discretion, and certainly anybody that works for people are going to be pretty upset too. So that's just a little small handful of changes. There's about 96 pages of new law, and it applies to all types of restraining orders. So we'll have other videos out in the future. So thanks for hanging in there with me. Just be aware that the more stress that we're in with our neighbors and stuff like that, there are more tools out there right now that either somebody who thinks bad against you, or if you want to try to use these tools against someone else, are out there, and there's a lot yet we have left to see. So please, everybody, try to get along. We hope to not get a lot of calls on restraining orders, because they're not a lot of fun. But if you have that type of situation, if you're dealing with the restraining order, we'll always consider getting involved to help. Again, my name's Attorney Lance Fryrear. My law firm's been defending people charged with crimes for more than 20 years, and we also try to handle this restraining order stuff. But this law may get me out of the business. If you have a situation, reach out to us. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.